Thank you, everybody, for joining. This is another episode of what we call here at Barth Calderon Wealth Protector TV, and it's our way of getting out just a lot of great value, educational content to you on topics that are hot, trending, and that can impact you in your personal and business life. And what we do for everybody that has an interest in these webinars, signing up, registering, is we record them. You will get a recording as a follow-up to this, so we'll email that out. If you give us about 2 days to get that edited, we'll get it out. So look for that in your email. And then also, as you're going through here, you're going to notice that there's just a lot of great information. I suggest you grab a pen and paper. There's going to be some eye-opening stuff that each of our guests will be talking about. But also, we offer a complimentary one-on-one session with any of our panelists, who I'm going to introduce here in a minute. And it's great. Gives you a chance to get with them, talk with them on any specific issues you have related to your planning. And so I'm Paul Hitchcock with Barth Calderon, and we are an asset protection, estate planning, business planning firm with a reputation across the country. And on the panel today, I have my colleague there, Brad Barth, who Brad is one of our top expert attorneys in all of those areas I just mentioned. Brad's in high demand for his talks that he gives across the country to a lot of different groups, including Vistage, the Women Presidents Organization, a lot of apartment owner groups. And so really glad to have Brad here talking about kind of the new world of asset protection, what's going on with anybody who owns property, owns a business, or has meaningful assets needs to know right now, and how COVID is impacting the asset protection world. So Brad, thanks for being here. Steve Williams is one of our close alliance partners of the firm and is a founding partner of Fried & Williams, a landlord representation firm in the Bay Area. And Steve also is a #1 speaker to many, many apartment owner groups. And Steve, thanks for being here.
Thank you.
Yeah, and then I have also Earl McCoubrey, who is my good friend and is an expert in the commercial finance world. Earl, can you hear me okay?
Yes, I can. Good morning.
Great. Earl's going to talk about some of the new guidelines that are going on in financing for property. And then I have Joby Tapia here, who is a managing director with NAI NorCal, and really is a sponsor with me of this episode. Joby is in the Bay Area and is an expert in property in many areas. Also is involved with the Marin Association of Realtors. I hope I got that name right, Joby.
Yes, you did just fine. I'm also serving as secretary for the Marin Rental Property Association. I've been specializing in multifamily property for the most part, though I have been doing shopping centers and other small triple net type of assets, including recently urgent care facilities. So I've got some ideas about what we're looking at in the coming months as far as what real estate assets might look like and how they may perform.
Yeah, that's great. So let's jump into this, and it's going to be sort of a free-flowing discussion here. I'll moderate. We'll jump around, and Joby, let's start with you, and maybe you could just give us, a few minutes of an update on your industry, what you're seeing, and what might be helpful for owners to know about.
Absolutely. Took some quick notes this morning to just talk about what we're seeing out in the rental market, especially San Francisco. As of April, there was only about 5.7% of the renters that weren't able to turn in their rents on time. And also that San Francisco, the market is one of the highest, if not the highest in the US for average monthly rental, exceeding $3,100 a month, which is, it eclipses New York City rents on average. We're starting to see a little uptick in inability to pay rents starting in May. Nationally, that number has risen to 22%. We're forecasting, especially in Marin, that it's more like about 12%, but that's still significant when it comes to the income for your asset. overall, the sales numbers have started to decline rapidly, especially in the multifamily commercial market. You're starting to see some panic selling a little bit from the commercial side, especially strip centers, retail centers. The rest of the market has just ground to a halt as far as actual turnover, especially in Marin. So what we're seeing is that there's a little bit of nervousness out there. I've got a deal that's in progress right now. It's a $4 million deal. Everybody's still moving along because we've got the rents coming in. We've only got 1 out of 13 tenants that has had some difficulty paying their rent. So that sale looks like it's going to continue on, but it's, I think, an outlier for what we're seeing in the rest of the market due to the slowdown. Everybody's waiting till June, July to see what's going to happen. Are the rents going to be consistent? And if so, values should hold up, especially in the fact that recent mortgage rates have been just ridiculously low as far as 5 and 10-year rates.
It's interesting you say that, Joby. I just have a comment because I got a call from a woman that called into our firm, and she owns 6 salons at strip malls. And, she said her rent's $6,000 a month for each of these hair salons that she has. She can't pay them. So she's not paying them because they were shut down. I think that's exactly what you're talking about, because the owner of that strip mall has these businesses like that just can't pay.
Oh yeah, I've got one client. I put him into 2 shopping centers in the Atlanta area. They were normally outstanding performers. The one that was closest into town, just outside the Beltway, or they call it the Loop, their April rents came in at 22% of the total, which was shocking. Normally that market had been performing outstandingly. His other one that we had just closed on about 3 months ago, fortunately was anchored by a Concerta urgent care center, and that one turned in 50% of the rents. But the rest of them, again, these retail centers are the ones that are hurting the most. They're usually small businesses. They're considered non-essential. So they have no ability to generate any kind of income in order to pay the rents.
Yep. And as you're talking, I'm just thinking of all of our other guests. These issues are all interrelated, with Steve, the landlord attorney, asset protection, and Earl. So I want to ask Earl, because I know, Joby, you interact with experts like Earl a lot on the financing side. But Earl, you and I were talking offline, and you had some very interesting kind of bullet points of the change in what's going on with financing. Can you tell us a little bit about that?
Yes, I'm with Fidelity Bancorp Funding in Santa Ana, California. We're a family-owned commercial real estate mortgage brokerage firm. So we finance commercial properties all over the U.S. and most of my work is here on the West Coast. Do a lot of multifamily, industrial buildings, as well as office buildings, retail, all those sorts of things, a few other items too. So what we're finding is that some of the lenders are just saying, you know what, we're out of this market. We're not going to take on any new deals at all until this is over. So some lenders have left the market, which reduces the amount of liquidity in the market. Those who are left have increased their requirements and their standards quite a bit. Right now, among multifamily, we really have to show that people are able to make the rents, and underwriters are doing things like reducing the incoming rents by 25% before applying their 5% vacancy factor. Not all are doing that, but a few of them are. And others are just making us are just underwriting based upon the actual rent coming in, which they expect to be less. The other thing they're doing is requiring an impound fund of 6 to 12 months, with 12 months being common, of principal, interest, tax, and insurance payments, sometimes also maintenance reserves in an account. So in other words, on the day of closing, whether it's a refinance or a purchase, why we've got to establish an account at a bank with 12 months of PITI and maintenance reserves in it, and that's there for in the event it's needed. Whereas people have to make their regular payments anyway, but the reserve is there for in the event that something happens, they can't make their payments. There's 12 payments there to draw on. Then they'll release that after a period of time. With some, it's a year. With others, it's 3 years. With others, it's other criteria. So that's really slowed some people down on the purchase side, mainly because they have enough for the down payment, the closing costs, but this reserve really increases the amount of cash that somebody has to put into a deal. So we see that happening quite a bit. Rates are still low, in the as low as 3.5, 3.6. A lot of rates below 4%. And there's a lot of lenders who are actually looking for deals. Call us up and say, "Hey, have you got something for us to work on?" So it's an interesting cacophony of different forces out there in the multifamily market. In the retail market, it's really, really tough to get a deal even looked at right now. Really tough. I have a few of them, and lenders are just saying, "No, we don't want to look at it at all. We have no confidence in retail right now." So we have to wait on that, and I'm not sure what owners are going to do in the meantime, especially those who have refinancing in order to meet a payoff deadline on their current loan. We're having to ask for forbearance quite a bit on those. Forbearance is another thing that's common in the market. People can't make landlords can't make their payments, and so they request forbearance or deferral. And so some of them have to, but on the other hand, we're finding that's something that people should only do if they absolutely have to. Because down the road a piece, a year, 2 years, 3 years from now, when people are doing things with financing, underwriters are going to ask, well, back during the pandemic, did you request or take deferral or forbearance? If the answer is yes, that's going to make it tougher. They'll actually hold that against property owners. So we're strongly recommending to people that they don't take deferral or forbearance unless it's absolutely necessary in order to preserve their financeability in the future. Those are a few of the things going on. Hotel, motel. A lot of lenders are saying they do not want to look at those deals right now. Office buildings and industrial, yes, we can do those. However, we do have to show that people are able to make their payments, that the tenants are paying rent, and the payments can be made.
Earl,
So
I have a question, and I just typed a message to everybody. You can start typing questions now as we get into this, and we'll answer them towards the end. But Joby, do you integrate highly with the financing people when you're working on deals? I mean, do you consider that a partnership?
Absolutely. There's a couple of loan brokers that I've partnered with over the years that I've really created a sense of trust with because they are a team member. For example, I sold a Walgreens in Atlanta about a year ago, and it was a particularly tough deal on the acquisition of it and then on the disposition. When we were in the process of acquiring it, the phase one had not been done correctly for this particular lot, and it was determined that there was actually some contamination that required a phase two. The loan broker that I used at the time was irreplaceable as far as her ability to have keyed in on very specific requirements and helped with the negotiation of how we were going to get that deal across the finish line, because we were in a time crunch with a 1031 exchange. So absolutely, loan brokers that know their stuff are just invaluable. You really can't do deals without really good loan brokers.
Yep, nice. Great, Earl, thanks for that overview there. Brad, I want to jump on over to you and getting into asset protection. You've been giving a lot of talks. Can you give us a state of the union address on what's going on with asset protection right now?
Yeah, sure. So thanks, Paul, and thanks for having me on as part of the panel. So what we're seeing, and my client base is business owners, property owners, and other high net worth individuals. So what we're seeing is basically a trickle down or a trickle up effect. I think both Joby and Earl had mentioned it, that when you have the underlying sources of cash flow are drying up, it has an effect kind of like upstream to where our client base is. And so what we're seeing is a lot of worry among our clients as to what's going to happen to their liabilities. Now, liabilities meaning financial liabilities and other forms of guarantees that they have. To Earl's point, as far as getting a forbearance or not getting a forbearance, I think ultimately that's going to be a business decision that someone needs to make, and whether short-term or long-term thought process. Again, much like people getting these, business owners getting the PPP loans, again, it's also maybe a short-term versus a long-term outlook. But I think it's important that that cash flow is one of the main concerns. And so but beyond just the cash flow issues, my property owners are always worried about liabilities. And so since there's liabilities associated with having rental properties and having tenants and having things that are beyond your individual control, this kind of now heightens that level of awareness. And so what we saw, well, actually what we're worried about seeing, Paul, is what we saw basically in the 2008, 2009 marketplace, where you had a lot of unemployment, you had a lot of depressed markets, and you had a lot of opportunistic tenants coupled with opportunistic plaintiff lawyers. And they were then coming after the clients or our clients, that is the property owners or business owners, as a source of potential recovery or economic relief for their clients. So that's kind of what we're worried about. We're always worried about landlord tenant-based liabilities. But now we're worried about it in another upstream, downstream. We're worried about what's going to happen from cash flow to our owners and their liabilities and their creditors. And now we're also worried about additional manufactured liabilities that may arise up against our tenants, our landlords and property owners and business owners as well. So it's you can call this a kind of a going towards a perfect storm of problems. And we have a weekly check-in at the firm, and we hear messages from our senior partner, and our senior partner is kind of giving us what the short-term as well as long-term outlook is from a liability perspective. And he's anticipating just a tidal wave of litigation that's going to come up from this, whether it's landlord tenant related issues, employee related issues, basically business owners against governmental entity related matters. So I think that the next 6 months to 12 months is just going to be a complete whirlwind of unknowns.
Yep.
Yeah.
Good overview. We've got some questions specific for you, Brad, but I want to jump over to Steve.
Sure.
And Steve, what's going on? A lot's going on in your area, but give us an overview of new stuff.
Sure. So I represent property owners and landlords, both residential and commercial. And of course, the primary issue I've been dealing with lately is panicked owners and landlords saying, my tenant can't pay the rent, or, what do I do? How do I handle that? And what was interesting to me is what Joby had mentioned earlier, and I'd heard this as well, the actual percentages of people in San Francisco or tenants in San Francisco who couldn't pay their rent in April. And I believe he'd mentioned it was about 5%, and that sounds about what I heard as well. And it's actually, seems to me to be a bit lower than what I had expected it might be. Now, to Joby's point, it probably is going to go up in May as time continues and people continue to not, be able to work effectively. Then those numbers are probably going to increase. So it'll be interesting to hear what those numbers are for May. But I thought 5% sounded a little bit lower than what I had expected it might be. But in any event, it still is, a main concern that I'm dealing with. And there are state laws. There's actually a federal law as well regarding a moratorium on being able to pursue a tenant for non-payment of rent right now if you have a sort of a federally subsidized rental unit or a federally backed loan for your property. But generally, it's your state. The governor has passed some laws that basically affect a moratorium on non-payment of rent evictions right now. There's also county, laws that present moratoriums on non-payment of rent evictions. as well as city laws. So there's all these different laws that property owners and landlords need to be aware of. And I saw we were going to have, in particular, the Marin Rental Property Association on. And Marin itself, the county of Marin, has its own moratorium. And that is similar to what you may see in other jurisdictions, as well as the state level, is basically for a period of time, a landlord or a property owner cannot give a non-payment of rent eviction notice to a tenant when the tenant cannot pay the rent due to the financial impacts related to COVID-19. And that's during the moratorium period. In particular, I know Marin County, their moratorium currently, I believe, runs through May 31st. That may have been or may very well be extended, as a lot of them are being extended right now. And same within San Francisco, that has actually been extended through June. There's a moratorium, as well as in San Francisco, for instance, there's after the moratorium has expired, there's a period of time that the tenant has to pay that rent that the tenant couldn't pay. And that's 6 months in San Francisco. So effectively, if a tenant is unable to pay rent in San Francisco for April or May or now June, they will have the ability to pay that rent back all the way until roughly January of 2021. So, and every jurisdiction is a little bit different. So depending on which city or county you're in, you may have these sort of long-term repayment, payment plan or obligations that are imposed on landlords that basically affect a long-term opportunity for the tenant to pay that rent that the tenant couldn't pay during the moratorium period. And in any event, the courts, even if you could proceed with a non-payment of rent notice right now, or even immediately after some of the moratoriums expire, you're probably not going to be able to get a lot done because the courts are effectively shut down. And I think Brad had mentioned this, there's going to be a logjam of litigation once the courts sort of reopen to these sort of things. Like right now in San Francisco, you can't even file an unlawful detainer action, which is an eviction action, until, I believe, really until August, I think it is, late July, unless it's for health and safety reasons or violence reasons. So your typical non-payment of rent, breach of rental agreement, things like that, you're not going to be able to evict a tenant for that for quite a period of time.
Steve, question. I know Joby addressed it too in the comments there, but someone's asking if tenant, and I'll just repeat this for the sake of everybody, if tenants cannot pay rent, can the landlord take the payment from the security deposit?
Yeah, that's a good question. Generally, generally no. I know that there are, and I have seen some specific moratoriums that say that the landlord can take it from the security deposit. In particular, in San Francisco, there is that provision for commercial tenancies. I have not seen it for residential tenancies. So I would be very, and again, you may want to check your particular jurisdiction to see if there's that distinction.
This is California, this person.
But generally, no.
Okay, generally no, yeah. All right. I got questions rolling in here. I'm just going to kind of move around here. So Earl, someone's asking, get this question here. Considering how common and pervasive requests for forbearance during the pandemic are, won't lenders need to discount the significance of a forbearance for future financing, assuming there has been recovery of the financial situation of the borrower?
That's really a really good question, and it goes like this: lenders expect investors and property owners to have a cash reserve. If you were to fly from, let's say, San Francisco to Singapore, you would know that the pilot has way more than enough fuel on board to make the trip, because things happen along the way that are unexpected. And it's the same thing with this here. Lenders expect owners to have cash set aside for in the event this kind of thing happens. And so if they are requesting forbearance or deferral, it suggests that they've not been doing that, that they've been running their property without a reserve of cash. And so that's what that means. Somebody who has a pool of cash for in the event something goes wrong and with the whole economy or whatever, and is not requesting forbearance and deferral, and has kept their payments up to date, the insurance has stayed paid, the property taxes stay paid and everything. Those are the people who get, who underwriters really appreciate the most. And so that's probably going to be part of the new normal going forward, is that investors and property owners simply take more of their cash flow and set it aside in a pool, have it managed to earn a return on it, something like that, but to have cash reserves for in the event things like this happen.
Would you recommend that if you have the funds, pay your loans monthly and not allow lenders to defer the monthly payments?
Oh, by all means.
Yeah.
So the absolute best thing to do is to use cash reserves to keep the principal and interest payments paid on time, keep the insurance paid up, keep the property taxes paid, and also keep the property maintained. Now, certainly capital expenditures like a new roof or, dig up the parking lot, replace it, those things will probably be postponed. But the regular cosmetic stuff and the health and safety items and the items that make the property livable, like new water heater, whatever that might be, or whatever, those things kept up to date.
Okay.
Yeah, that's the best situations that a investor can have themselves in.
Okay. This one's for Brad and Steve, and a couple issues here. And Brad, your mom would love this one because it's about cats. And so here I'm going to read this, and it's coming from somebody that I believe attended one of our workshops a while back in Vegas. I was inside a single family rental unit last week and discovered a very content cat. Our rental agreement does not allow pets of any kind. The tenants are pretty concerned and perhaps consumed with the COVID news and stay in place issues. I don't think it's a therapy animal. I'm guessing the cat is a distraction and comfort for extended stay at home orders. I don't mind the cat in the short term. I'd like to look the other way, but I don't want the cat there. Basically, in the long term, there's no pets. They didn't call and ask. So, thoughts. So, how do you deal with that issue, that particular issue? Steve, you may want to jump in. And
yeah,
then Brad,
I think this is
there.
more I think of a Steve question, and unless it's some type of wild animal. When you say cat, you mean like a lion or a tiger with strict liability issues. I think people's super sensitivities to animals and breaches of lease agreements regarding no pet provisions. I'll let Steve address this one.
Yeah, the second part, Brad, is going to be directed at you. But Steve, what would you do about that scenario?
Yeah, Brad, to follow your point, the comfort tiger may be legal in some states, as many of you probably saw with that Tiger King series, but not in California. So you can't have your comfort tiger in California. But this is these cats, and animals. This is a typical question I get, pre-COVID-19. I haven't really had a lot of these since, but basically, there are some prevailing fair housing laws that would require a landlord to allow a cat, if reasonable, to accommodate a person's disability. Here, it sounds to me like the tenant has not yet, one, requested the animal, or two, indicated any sort of a disability that might invoke those fair housing laws. So my recommendation here would be, if you ignore it and don't do anything about it, turn your back on it, then that's really tantamount in my world to authorizing it. If you continue to accept rent with knowledge of a breach of the rental agreement, then you very well, in the residential context, are probably going to be construed as waiving that provision of the lease. So my recommendation here is to call the tenant on it. I suspect the tenant will probably respond with some sort of a generic doctor's note, as I frequently see, or some statement that look, I have a physical or a mental, which is most typical, a mental impairment, and it's a disability is so broadly defined that virtually any type of an impairment will qualify, and that having that cat is an accommodation for that impairment. And in that situation, then the animal would most likely be permitted on a permanent basis as a comfort animal for that particular tenancy. But if you are inclined to take any sort of action, you're just not going to be able to do that right now. But I wouldn't recommend that you turn the other cheek at this point.
Right. Okay. Brad, this is part of the same question, and it gets into liability. Four people renting a unit together. So 4 roommates found each other, not related, found each other, been living together for a while. And one of them is bringing family over and the others are concerned about it because of the COVID thing. So this one person doesn't seem to care very much. So my question is, and we've seen this also with people having guests and walking around common areas of a building. First question to you, Brad, is what is the potential liability there for a landlord where, this is happening, somebody maybe gets sick, is the landlord exposed here when people are doing this?
Yeah, we addressed this on a previous talk, and Steve, you can certainly help in answering this question. But my concern is that it goes back to what I referred to last time as the invisible boogeyman, right? You don't know exactly what the source of a problem is. So unlike, and I used the example before, if somebody rear ends you, you can look at the front of your car and the rear of somebody else's car, and you can kind of figure out who's at fault. In a case like this, you just don't know. And so you go after the deepest pockets. So if it was the roommate next door, well, the fact that he's a tenant probably means that he's not have a lot of money, because he's not the property owner. He's the one that's renting one of the rooms. So if I have an option between going after my fellow roommate in the next door or going after the property owner for some type of negligent lack of supervision or some of the maintenance of the common areas, well, I'm certainly going to go blame that person because that's where the deep pockets are and that's where the insurance policy lies. So, and as I said, with the invisible boogeyman, it's prove me wrong, right? What's the source of the virus? Whether am I pushing a button on an elevator? Am I holding on to a handrail? Is it the guest that came in next door? And you're hearing these crazy stories on the news where people are really basically turning on their neighbors for these exact reasons. I think that the liability always goes upstream, and as a landlord, I don't really know what the solution is. What are you going to put a security guard at all of your single family homes and prevent people from coming in? I think it's a difficult situation, but I think it boils down to, because it's an invisible boogeyman, you don't know what the true source of liability is. So it's very easy to take something, throw it up against the wall, see what sticks, and puts the owner on the defensive. Right.
And Brad, this is where you start talking about, as it's getting frothy out there with tenant issues,
yes.
and arrows pointing at
yes.
the deep pockets. This is where you start talking about proper legal structures
right.
for rental property LLCs. I mean,
right. And I'll tell you, just based on personal experience, many times over, even though you're completely innocent, the fact that you're getting called out on something, you're now going to have to lawyer up. You're going to have to respond. There's a cost associated with that, and then when a plaintiff's attorney can smell blood because they see that there's assets out there to go after, again, there's all kinds of things that can be done to progress, to coerce, and it doesn't necessarily mean it's a level playing field. So what we try to do is position
Brad,
yes.
Oh, that's sorry, I didn't mean to interrupt.
No problem.
So we had a situation very similar to that in this deal that I'm currently selling, and we had one tenant who was pretty much ignoring the shelter-in-place rules by having guests over.
Mm-hmm.
And the way that we started this procedure is that we sent a letter quoting Marin County guidance about shelter-in-place, mm-hmm. and demanding that she cease and desist by having guests over. So that was one one avenue of risk mitigation that we took by going on the offensive and notifying the tenants that this is not allowed.
Right, fantastic. Yeah, I call that building a file. Right, it's always what you do. You want to paper the transaction, you build a file. You've done all that you possibly could to try to mitigate your liabilities, because as I mentioned, when the complaint comes, at least you're going to have something to fall back on. Notices, we tried to enforce it, we gave them knowledge, and then they did it notwithstanding, right? So and that applies to anything, not just COVID issue. It can apply to anything. Building a file and having a proper paper trail, correspondence trails is always advisable. So Steve, what are some of your comments on this?
Yeah. So so Joby, that's a great idea, and even before you get to that situation, I've been advising landlords now to send out a letter even before the tenants start potentially violating these laws, and it's just sort of a generic letter I put together and help landlords send out saying, look, this is going on. Here's the CDC's website. Here's the local agency's website. Please ensure that you're, properly maintaining your unit, properly washing your hands, maintaining a safe social distance from other tenants in multi-unit buildings. So basically to respect the privacy and distance of other occupants of the building, just sort of a generic get out in front of it type of letter. But then when something like that does happen, where, and I've given the example of those many times in these talks, given the example of those, the college students, the party goers out in Florida who are just ignoring the laws. Well, you may have tenants doing the same thing who are throwing COVID-19 parties. Luckily, I haven't had clients that have had that happen, but I've actually seen that in the news where people are doing that. And when that does happen, then I believe that you do have an obligation to respond specifically to them, put them on notice, give some sort of a warning or threat to even evict, because they are putting the building, at risk. And I believe that is one of the types of unlawful detainer eviction actions that you could push through a court right now, is one where there is a health and safety issue.
I've got a question here. Will the moratorium on mortgage payment be reported negatively on your credit bureau report? Who can answer that?
That's a pretty good question. Usually the mortgages for 1 to 4 unit properties, investment properties, show up on personal credit reports, and so it would show there. On the other hand, when it's 5 units and up, those loans usually don't show on the personal credit report. And so if there was something going on there, then no. However, underwriters will pull a report called a LexisNexis or equal, and what that does is it shows all of the actions that have ever been taken in connection with this particular investor through courts and through other means, through other measures. They look at all the public records and report all the public records on a person. And so if there was ever any kind of action taken by the lender in connection with that, then it would show there. So so it's pretty hard to hide things if the lender has taken some sort of action.
Got it. If the tenant insists on renegotiating current rent downward, must the tenant provide proof of inability to pay?
So most jurisdictions, the local ones, require the tenant to provide some proof of an inability to pay. There are a few exceptions, but in general, yes, the tenant has to provide some proof in order to avail themselves of the moratorium to not pay the rent during that particular month or period. And then again, that may trigger some deferment of payment. Now, I have not seen any jurisdictions that say that the landlord has to reduce the rent or that the rent never has to be paid. Now, I'm not saying that's not coming and that there's not some proposed legislation in some areas to do that. But as of now, I'm not aware of any obligation the landlord has to actually reduce the monthly rent. I am generally advising clients not to do that, but instead to work out some sort of a deferment payment plan where they actually pay that rent later. That being said, I have had some clients who have actually temporarily reduced the rent because they want to. You know, they want to be, you know, good in this particular situation. In fact, I have a rental property myself, and I offered to do that for my tenants. But you're not required to do so. I'm generally advising that you know, first approach the deferment option. And if that's not going to work and the landlord wants to give some sort of temporary rent reduction, that's generally okay. But that being said, I would look to some, you know, as you know, there now is, well, maybe you don't know, but there's now, as of January 1st, statewide rent and eviction control in California. And there's always been, you know, local jurisdictions that have very strict rent controls. My concern is that if you temporarily reduce it, depending on the jurisdiction you're in, that may be considered a permanent rent reduction. So you just want to consult with an attorney and make sure that you cover your bases. And if you are going to offer that temporary rent reduction, that it's not a permanent one. So first focus on the deferment. If that doesn't work, then consider an actual temporary reduction. But that needs to be in writing, and you should probably consult with an attorney to make sure it's not a permanent one.
Yeah, I'll let me just address on that point also. I'm sorry, Joe.
That's right.
Because this actually is top of mind. We actually just dealt with this earlier this week, as a matter of fact. Late last week, we had a property owner reach out to us, and they did speak with their tenants regarding a deferral. And so we did put together basically a written agreement giving them 3 months basically of a deferral, but it was very clear that it was not in any way modifying the remaining obligations under the lease. And so that was to your point, Steve. So I think that's a very good piece of advice, to have the agreement in writing and understanding that is not changing the actual rent obligations for the remaining term of the lease.
Toby, you had a comment?
Yeah, Steve. So I have an associate who has a property out in the Chico area. And one of the things that I've heard, not only from him, but I've heard from others, that there's some tenants that are taking advantage of this situation and going on rent strike, even though they do have the ability to pay. My advice to him was to notify that tenant that that rent is due at some point, and it will reflect on their credit report if they continue to not pay the rent without making some sort of arrangement to get it back in a timely manner.
Yeah, now fortunately, it seems like most tenants seem to be on the level. I haven't seen a lot of situations where tenants are taking advantage. At least it doesn't appear to be the case. But you know, there will be tenants that do take advantage of the situation and avail themselves of the moratorium protections. And no, that's great advice. Again, they will have to pay it at some point. You know, most jurisdictions, all jurisdictions, they do have to pay it unless something changes at some point. But putting them on notice that, well, fine, you will be obligated to pay it. So let's say the moratorium in Chico or in that area is lifted June 1st, they're obligated to begin paying June rent and possibly even the back rent at that point, unless there's a deferment period of time. But once that deferment period of time is up, then the landlord may be able to give that 3-day notice to pay rent or quit and evict the tenant, or have it show up on that tenant's credit report, you know, as a negative reflection.
And just for all the listeners out there, the Marin ordinance, it goes through July 24th for non-payment of rent actions.
Okay. Brad, this question came in via cell phone here. I'm reading it. So this person has franchise businesses.
Mm-hmm.
So they have multiple locations, and the businesses are suffering tremendously, and they have personal guarantees for these franchises. They also own rental property,
Mm-hmm.
and which is why they were asking this question on this webinar. But they're worried about something happening with their franchises and having creditor issues there that maybe impact their rental properties. Can you address how those might be related and what you talk about there?
Yeah, sure. It's just that trickle up, trickle down effect. It's just that simple. When you start, start drawing up your cash flow, it doesn't mean that your obligations as a business owner or as an individual go away. And especially if you have personal guarantees. And one of the challenges with personal guarantees is that they're typically unlimited in time and space, meaning that they last forever as long as there's an outstanding obligation on the loan, and they're not necessarily limited as to what category of assets can be reached at for satisfaction. So personal guarantees are very difficult because it really empowers a creditor or a lender to pretty much go after any asset, and really can be an emotional as well as a financial strain on the person that's obligated to pay that. So whether the obligations or the difficulty is coming as a result of businesses or as a result of lack of cash flow from your tenants, the issue is still the same. But here, I think, Paul, is a bigger issue that should be addressed, which happens to be with timing. Because in my world of wealth preservation and any form of asset protection, the timeline of putting things in place is very important. We like to do planning before the need arises rather than reacting to something. And that's huge. Because when you start reacting to things, to known or reasonably should have known or ascertainable type of creditors, now there's certain remedies that kick in for the let's call it the plaintiff or a lender that can undermine the attempts that you're doing to protect those assets through whatever mechanism that you're using. And so this current environment, there's a very easy argument that can be made from anybody, especially when they're trying to foreclose on a personal guarantee, that regardless of what you did from an asset preservation perspective, you certainly should have known, right? Storm clouds are on the horizon, man, right? And which makes it very difficult to just move things around. And therefore, working with a professional who can help to tell you where that Goldilocks zone is, what you can do under these circumstances, certainly it's going to be to their benefit. So to this person, being able to plan is absolutely an option, because just because you have some difficulties and just because you have some challenges with your franchises and your properties doesn't mean that you as a business individual, as a business professional, still can make some decisions to basically consolidate, to centralize management, to do other things that you're worried about, from tenant-based liabilities, from COVID issues. So there's things that can be done, but we now have to do it a bit more carefully, because whatever we're doing now under this environment is going to get a level of scrutiny that wouldn't have happened had you done the exact same planning 6 months ago, right? So the tools are available. It's just that be wise about it. Right?
What about this question? What about a non-recourse financing on a refi on multifamily? Will the borrower be personally liable?
You coming back to me, or was that one for Steve?
I don't know. I mean, Brad, maybe that's you and Steve and anybody else, but
I'll just address it on the quick end, and I'll hand it over to one of the other panelists, because that just to me is a trickle-down liability issue once again, right? That's all. So you have an obligation. They look to your individual assets. They look to the reserves that Earl mentioned previously. And so I'll just kind of hand that contractual matter down to Steve or Joby.
I think that's probably best answered by Earl. That might be right.
Well, part of that is whenever there's a non-recourse loan, that's really, really great, but we have to read the loan agreement, because some of the non-recourse language, well, wait a minute, back up a little bit. Non-recourse usually comes with what are called carve-outs. So there's no personal guarantee enforceable on this loan unless the loan was made with fraudulent information, or unless this or that or the other thing. The thing is that some of the non-recourse language you really can't comply with. So so some of it is pretty okay, but some of the non-recourse language is pretty tough for a borrower to comply with. So on the surface it says non-recourse, but then when you go and read the carve-outs, that is non-recourse except if language, then all of a sudden it's like, oh my gosh, I really am personally guaranteeing this, even though it was advertised as a non-recourse loan. So we really do have to read read the language to make sure, so we understand where we are. There's certain kinds of loans, such as what are called conduit loans, and I think Kobe is probably well familiar with those, where non-recourse is non-recourse. There's no recourse. But on Fannie Mae, Freddie Mac loans, as well as other types of non-agency loans, we really do have to understand the language.
Joby, you have any thoughts there?
The only ones that I've seen that are truly non-recourse that I've worked with are the CMBS, commercial mortgage-backed security type of loan. Those are difficult to work with insofar as that they go to committee on the way in. There's higher standards of lending. And then on the way back out, they're pretty, that goes to special servicing. If there's any kind of issue with non-payment, special servicer will try to work out some sort of modification or some sort of repayment or some sort of timeline, because ideally they want to get things to go status quo ante versus taking the property back. Last thing bank wants to do, especially on a CMBS loan, is to own, or to have REO or real estate owned, because then they have to dispose of it and it gets pretty sticky. So they generally like to try to work it out versus getting into the weeds of owning the property and running it.
Yeah, and the question was related to non-recourse on a refi versus on a purchase, if that makes any difference. Yeah.
Well, I haven't really seen a whole lot of fully non-recourse. There's usually some sort of clawback that the banks have. Like Earl was telling you, you have to look at what the carve-outs are in the loan language, and they vary widely from full recourse to some sort of cross collateralization. So it really does depend on the unique loan language in that particular loan.
Got it. Fantastic. Well, we were going to run this for about 45 minutes, and so we're running on from there. I just want to say, Earl, Brad, Steve, Joby, thank you so much for being a panelist on this. Great information. I know there's a lot more behind it. I want to thank everybody who stayed on for this, attended, and again, look for the email from me as a follow-up with a recording of this, and with your chance to get one-on-one with anybody here for assessment of your own situation. And yeah, I'd love to have everybody back on again, and we'll keep everybody updated.
All right, thanks a lot, Paul.
Thank you, Paul.
Thank you, Paul.
Thanks, everybody.
Thanks, everyone.